My topic today is, are irrevocable trusts really irrevocable? In my 19 years of practicing trust and estates law, I can't tell you how many times clients forget the terms of his or her irrevocable trust and then mutter the sentence, can't we just change it? They completely forget that warning that we all at Cummings and Lockwood put pretty early in our cover letters in bold, highlighting that the terms are irrevocable and you should review the provisions carefully. So in preparing for this presentation, I can truly understand why people hate lawyers, because we use the words irrevocable as something that cannot be changed by the grantor or creator, but then we give 9 ways that you can change it. The word irrevocable is essentially neutered down, so it's changeable by everyone but the grantor. So today I'm going to focus on the newish ways we can change irrevocable trusts, and that's decanting and modification. Both of these are relatively new to Connecticut. Connecticut has trailed behind the other states, and it's finally gotten on trend by passing modification statutes and decanting statutes. In Connecticut, you no longer need to really break the trust. You can follow these statutes to change or modify or decant the trust to get the desired provisions. And I'm going to leave the heavy lifting to the funnier Dan for the next presentation, because I'm going to tell you what you can do under state law, and Dan's going to tell you why you might not want to do it under federal tax law. So to get on trend, Connecticut enacted 2 particular statutes, the Uniform Trust Code that was passed way back in 2019 and effective January 1, 2020. That law changed a lot of the aspects of Connecticut trust law. We got the 800-year rule against perpetuities. We got self-settled asset protection trusts. We got notice to beneficiaries, which everybody seems to still ignore. One of the less covered topics was in the Uniform Trust Code was allows for non-judicial settlement agreements and judicial modification. This summer, out of nowhere, June 5th, we got Governor Lamont to sign the Connecticut decanting statute into law with little fanfare at all. I guess it helps to have a governor who cares about trusts. However, the decanting statute is not going to be effective until January 1 of 2025. I'm going to start with decanting, even though it was a later passed statute, just because it's the breaking news. We've touched on the modification in other of our prior seminars that we've done in the past. It's also more fun to talk about wine early in the morning than modification. So in the wine world, decanting means pouring wine from one container to another to help awaken the flavor and expose the wine to oxygen. Decanting in the trust context is when the trustee exercises their discretion to distribute property from an old trust and distribute that property to a new trust instead of distributing it outright to a beneficiary. This is a unilateral act of the trustee and hopefully by an independent trustee. The concept originated in Florida in a very old and famous case, Phipps v. Palm Beach Trust Company. And this case stands for the proposition that if a trustee has the power to distribute to or for the benefit of a beneficiary, they can use that power to distribute to a lesser extent and distribute it to another trust for the beneficiary. As I mentioned, the decanting statute was passed this summer. It will be effective for all trusts whenever they were created after January 1, 2025. And so to use the Connecticut statute, it has to either be administered here in Connecticut or the trust agreement has a Connecticut choice of law provision. For those of you that are familiar with New York's decanting statute, you're going to see that our statute's pretty similar, but a little more restrictive. This is the most important slide. There are 3 key definitions here. If you can understand this slide, you will know what you can and cannot do when you're decanting. Really, it comes down to these 3 definitions. So the first definition is a vested interest, which is a right to a mandatory, non-contingent distribution of whether a right of withdrawal over income, a dollar amount, or percentage value. So for a vested interest, think if the beneficiary is getting $100,000 per year, that's a vested interest. If the beneficiary is getting the net income, that's a vested interest. If the beneficiary has the right to withdraw 5% of principal, that's a vested interest. It's a set standard. The next 2 definitions, they're going to be what triggers what you can and cannot do in the decanting. So expanded distributive discretion means your trustee has the power of distribution, and it is not limited by an ascertainable standard such as health, education, maintenance, or support, or some other reasonable definite standard. So here is where you think the magic words are sole, absolute, and uncontrolled discretion. And if your trustee has that, you're going to have certain rules about what you can and cannot do. The third definition is limited distributive discretion, obviously the opposite of the last definition. This is a trustee's discretionary power that's limited by an ascertainable standard or is reasonably definite. And if your trustee has this power, the rules are a little different than if you're under expanded distributive discretion. So every trust agreement out there is going to fall into one of those two categories, and it will dictate what you can and cannot accomplish in your decanting. If your trustee has expanded distributive discretion, remember, think absolute discretion. This slide shows you what you can and cannot do. You cannot, under any circumstances, remove or reduce a vested interest. If the person gets $100,000 in the old trust, they have to get $100,000 per year in the new trust. You can't get rid of any vested interest. And you'll remember, that Powell v. Ferry case several years ago, convoluted case, Massachusetts, Connecticut law. But that was a right of withdrawal. That, if you were under the new decanting statute, Powell v. Ferry would have had a very different outcome. You cannot add beneficiaries in the decanting if you're under the standard. And I'm going to put an asterisk on that and come back to that. You are permitted to extend the term of the trust, reduce or eliminate a non-vested interest, so you can get rid of beneficiaries if you have this expanded distributive discretion. But you can't get rid of any vested interest, but you can get rid of a beneficiary that has a discretionary interest. In this decanting, you can add a power of appointment that includes non-beneficiaries. So I just said you can't add beneficiaries, but you can start the process of adding beneficiaries by giving someone in the new trust a power of appointment to add a beneficiary. So it makes adding a beneficiary a two-step process, not just the trustee is able to do that. If the trust agreement has limited distributive discretion, this slide shows what you can and cannot do. You cannot add or subtract beneficiaries. You cannot change the discretion standard during the period of the old trust, and you cannot modify the power of appointment at all. And again, you cannot reduce or eliminate a vested interest. You can extend the term of the trust and reset the discretion standard for that period of time after the initial term of the trust. Again, this sounds very similar to New York's statute. Regardless of which discretion standard the trust agreement provides, you cannot use a decanting to increase trustee compensation without court approval or all the qualified beneficiaries' consent. Qualified beneficiaries here in Connecticut are those who are currently eligible for income and principal distributions and those persons that would receive the trust property if the trust ended at that moment. A decanting cannot eliminate any person's power to remove or replace a trustee without that person's consent or without court approval. And the trustee is subject to a fiduciary duty doing the act of decanting. So it's in a fiduciary responsibility that they're going to make this discretion. But the statute's clear that a trustee does not have a duty to decant, and I'm sure that was put in there to make the banks happy. Turning to the mechanics of decanting in Connecticut, there are notice requirements. As I mentioned earlier, the act of decanting is a unilateral act of the trustee exercising their discretion to distribute assets to a new trust. They can do this without the consent of any beneficiaries, but if they are using the statute as the basis for their authority to decant, they must give notice within 60 days of the decanting, and they must give it to the old trust, the people that created the old trust, and any of the qualified beneficiaries, any holders of powers of appointment, any fiduciaries, and anybody with the right to remove or replace trustees. If you have charities involved, you must also notice the Attorney General. And if you have special needs trust, you have to notice social services. If you have designated representatives, which we've talked about in the past, you can use that for the notice requirements. Any of the people receiving the notice now have a statutory right to go into probate court to try to reverse the decanting if they wish to object to it. When do you need to get a court involved? If you're dealing with a trust under a will, you must petition the court to do a decanting. There's just no way around it. If you want to choose to go to a court to get either approval of the decanting, the probate courts are now authorized to approve a decanting, rule whether or not the proposed decanting is consistent with the trustee's fiduciary duty. They can even appoint a special fiduciary just for the purpose of decanting. And again, if you are going to change the right of removal or replacement and you don't have consents, or if you want to change fiduciary compensation and you don't have consents, you have to go to court. On this slide, I've shown my decantings, do's and don'ts. The first is really important. Read your trust agreement. If the document prohibits a decanting, you can't use the statute to then accomplish it. Also, if you have Cummings and Lockwood documents, we've had decanting provisions in our documents for probably 10 to 15 years. So if the procedure and the method is better under the document, it may be preferable to use that method instead of using the decanting statute. If the statute does not override your power that you already have in the agreement. On a practical level, I don't see people using the statute frequently to add and remove beneficiaries. I have a hard time reconciling how you do that in your fiduciary duty. How do you remove a eligible beneficiary and say it's in their best interest? Similarly, how do you add someone or start the process of adding someone and say it's still good for the current beneficiaries? It just doesn't seem to reconcile. So there is a fiduciary duty. How could it be in the best interest? So I just don't see people using this to add and remove beneficiaries, but it is possible under the statute. I do see the statute being used to fix old trust provisions that you just want to get out of, whether you want to add administrative provisions or something else, moving from grantor trust back and forth. This is for humor. I've included the actual decanting do's and don'ts for wine. For all of you in the room with the most basic wine knowledge, you already know this, but I learned don't decant wine over 50 years, maybe because I've never had wine over 50 years. My cellar might last only till 2023, so let's turn away from decanting. This goes back to the 2019 adoption of the Uniform Trust Code effective January 1, 2020. The most commonly used, intentionally or unintentionally, is non-judicial settlement agreements. To be a valid non-judicial settlement agreement, you can't violate a material purpose of the trust, and the agreement must have terms that a court would approve if you went to seek the approval. You can only use these agreements in Connecticut to get the parties to agree to this specific list of things: for the interpretation of terms of a trust if there's ambiguity, approve a trustee's reporting or account, the resignation or appointment of a trustee, and transfer place of administration, and to waive or approve a liability of a trustee. The agreement must be signed by all the interested parties, which are those people that would get notice if there was a court proceeding. And under the Uniform Trust Code, again, that comes down to those qualified beneficiaries, those people eligible for income or principal, and those people that would receive the trust property if the trust ended at that moment. The use of non-judicial settlement agreements is only authorized for inter vivos trusts. You really can't use these agreements for trusts under wills in Connecticut. If you're dealing with a trust under a will, you must go to court to modify or terminate the trust or accomplish your goal. You can't use it except for the purposes on this slide. Anything outside of that, you have to fall into the other exceptions that are in your materials. The other thing to remember for those bankers in the audience, a non-judicial settlement agreement also includes a receipt and release. So if you're getting a receipt and release from your central office, you got to make sure that form complies with the Connecticut statute to have it binding on all the parties. If you can't accomplish your desired changes using a decanting or non-judicial settlement agreement, the Uniform Trust Code gives us 7 other statutes that I've listed here. I'm not going to cover all those to allow us to modify or terminate. Each of these require a judicial proceeding. The petition may come from the beneficiary or the trustee. Don't think there's a form for a lot of these because there's no probate court form, so this is normally hand drafted to the whatever the situation is. You're going to look at the court that has jurisdiction, and you need to find either where the grantor resides, or if the grantor is deceased, where his or her will was probated. And if you don't have a trustee in that jurisdiction, that's the only way you can get down to where the beneficiary resides. In my materials, 95 through 104, I've outlined the 7 other statutes that allow you to change or modify a trust. As you'll see, there's a general pattern. Everything's more flexible. I won't bore you with all the details, and I will let Dan bring on the humor and the tax advice.